As the chief law officer of the state, there's been many comments about the length of this trial. Do you have anything to say about that?
It's outrageous. I mean, of course, that's no criticism of the judge. He's doing everything he can to control it, but again, without reference to this case, our system has deteriorated to the point where the trial of a criminal case is more like a circus than it is a judicial proceeding, and I've said and will continue to say we have to perform major legislative surgery on the system or it's going to collapse.
Mr. Attorney General, it's nice to see you here today.
Good to see you.
What are you anticipating in this trial? Why are you being called and by whom?
I understand that Mr. Kenerick has had a subpoena out for me, and I just want to make it easy for him. I haven't the slightest idea what we're going to talk about, but I'll be happy to see you I was going to say a few minutes, but that's not very realistic. I'll see you when I'm through.
Thank you.
I don't think there is any such thing as ordinary in a case like this. Thank you. Excuse me, gentlemen, I'll be with you. Hopefully, it's over this way. Down there. Get it.
Mr. Younger, what do you have to say about this morning's testimony?
Well, most of the questions addressed to me involved a meeting which was held in the District Attorney's Office on December 4th, 1969. The meeting was attended by members of what was then my staff in the District Attorney's Office and by attorneys representing Susan Atkins. At that conference, a certain agreement was reached with respect to what the prosecution would do in certain circumstances. Immediately after the conference was over, I asked Mr. Stovitz to prepare a memorandum covering the conference. He did so. The memorandum was prepared and is now in evidence, and if you gentlemen would like a copy, you may have it.
Why did you decide not to continue to offer the arrangement to Miss Atkins? Why did you decide to change that and seek the death penalty?
I testified to that in court this morning, and I'm not certain whether the judges would consider my repeating my testimony and that to that question is proper or not. So out of an abundance of caution, I won't answer it, but I will invite your attention to the transcript where I did precisely answer that question.
Has the prosecution ever...
that your office in any way violated the agreement that it had with Miss Atkins and her attorneys?
No, sir.
Why?
For reasons I stated in court in the last couple hours.
Do you feel that Miss Atkins was not telling the truth?
Again, I answered that very precisely from the stand, and you'll have to forgive me. I don't want to get involved in any argument with the judge over semantics. It might be argued that since I testified in there, I ought to be able to repeat it now, but I'd prefer that you refer to the transcript.
It's always been the practice, Mr. Younger. It hasn't been considered a violation of the gag order.
Well, I probably might be subjected to a little more strict interpretation of the rules under the circumstances, and that's so long as I did answer it all on the transcript, why, I think I won't again.
Did you feel that your questioning was, your answers were rather evasive?
This morning?
Yes.
You got to be kidding.
Mr. Younger, you testified that you studiously avoided reading any publications concerning the Tate LaBianca murder case. Why did you choose to avoid reading about the case?
It's very unpleasant reading. I have a number of things which I had to do as Attorney General, and, or rather, had to do as District Attorney and now have to do as Attorney General, which require me to read hundreds and sometimes thousands of pages, often with regard to very unpleasant, very gruesome, very bloody activities, and I do that to the extent that it's required, but rereading about these same things in a newspaper just when I'm presumably on my own time and have some choice as to what I want to read is not my idea of a pleasant postman's holiday.
At the time of the Susan Atkins confession, the publication of that confession in the Los Angeles Times, did you make any effort to find out how the Times had gotten a hold of it and then printed it in light of the fact that you were the county's chief law officer and a gag order had been issued by the court?
No, sir, it was not my gag order. I didn't make any attempt to find out how the Times had gotten it. And again, as I've explained this many times, this has no reference to the present case. One of the troubles with a gag order is that a judge can write any kind of an order he wants to, but a defendant in a murder case is not going to pay a blessed bit of attention to it. What are you going to do to a defendant who's may be sentenced to the gas chamber? Say to that defendant, since you talked to a reporter, I'm going to give you 5 days in jail for contempt. I'm speaking not with reference to this case, but with reference to gag orders generally. So when the story of this defendant was printed in the Los Angeles Times, big deal. Who was surprised? We all anticipate that at some point a defendant in a major case is going to talk to reporters, and there's never been anybody yet figure out a way to prevent it, and I'm not even sure it's, even if you think it's a good idea to prevent it, there's no way to do it.
Mr. Younger, what was the policy and what is the policy of the District Attorney's Office regarding the death penalty in the Tate LaBianca trial?
Well, the District Attorney, when I was District Attorney, was seeking the death penalty and apparently still are.
Mr. Younger, do you think that Miss Atkins' story in the Times, as you know it, based on what you understand, is more closer to the truth than what happened in the Tate LaBianca case than what she told the grand jury?
I haven't read her story in the Times. I don't know what she says there.
Nowhere on the manuscript or the accounts what you've heard or...
Right. I have not read it, and so I couldn't answer your question.
Mr. Younger, there...
Certain lawyers as qualified, and lawyers that are not qualified should not be permitted to try a capital case. That's one of the provisions we're going to include in our package.
Now, at the beginning of this trial, you offered the Supreme Court evidence of Mr. Kanarik's, quote, incompetence, end quote, as I recall. After seeing his performance this morning, what is your attitude, or has it changed from that time?
It's with great reluctance. I don't think I can properly answer that.
Mr. Younger, were you personally responsible for both decisions regarding Susan Atkins that came out of the District Attorney's Office?
I approve both. In that sense, I was responsible for both of them. Yes, sir.
Could you tell us what the arrangement was, Mr. Younger?
I'll give you a memorandum.
Would you do that, please?
Yes, sir. Thank you. It very clearly spells it out, and this is in evidence. You can all have a copy of this.
On the question of competence of counsel...
Well, wait a minute. Let him answer the question.
Well, I don't want to read the memorandum, but I'll just give it to you.
Could you just verbally tell us what the arrangement was?
The arrangement on December 4th was that... I think it was proper. It has nothing to do with my being on the witness stand. Our actions early in the trial, our actions to try to force a determination by the appellate courts prior to trial that a certain lawyer was or wasn't competent was, in our opinion, in the public interest. We hate to be put in the position on appeal. We have been many times where a defendant who's convicted will get a new lawyer, and the new lawyer will come into court and say that this defendant was not adequately represented at the original trial, therefore he didn't get a fair trial. And no one questions but that that's going to happen in this case, and naturally we felt it was in the public interest to try to avoid it. We could not avoid it.
If that were to occur, and the confidence of the public